Today, we are diving into a really fascinating Supreme Court case. And honestly, it's a really big deal for anyone with a serious side hustle. You know, a passion project that costs some real money. This is the story of how one man's fight over his horse racing business literally changed Canadian tax law. So let's just get right to the heart of it with the one question that started this whole thing. Can that expensive passion of yours, whether it's farming, racing, art, whatever, can it actually save you money on your taxes? I mean, this is the classic showdown that pits entrepreneurs and hobbyists against the tax man year after year. And that brings us to the guy at the center of our story, a man named John H. Craig. His fight is the reason we're talking about all this today. Okay, so check this out. By day, Mr. Craig was a successful lawyer. But his passion, his other life, was in a completely different world. He ran a professional horse racing business. So he had these two major things going on. And this kind of split focus is absolutely crucial to the story. And let me tell you, this was no small hobby. In the year 2000 alone, his horse racing business lost more than $222,000. And he had big losses the next year too. I mean, this wasn't just pocket change. It was a serious financial operation with very real stakes. So here's the rub. Mr. Craig did what a lot of business owners do. He tried to deduct the losses from his horse farm from the income he was making at his law practice. But the Canada Revenue Agency just stepped in and said, nope, you can't do that. And that set the stage for a legal battle that was going to go all the way to the top. Now, the thing standing in Mr. Craig's way wasn't some minor regulation. It was a legal giant, a powerful 34-year-old Supreme Court decision called Moldowan versus the Queen. This ruling had been the undisputed law of the land for decades. So basically, this old Moldowan rule created these three rigid boxes to put people in. If farming was your full-time job, your main source of income, great, you could deduct all your losses. If it was just a hobby, something you did for fun with no real business plan, you got nothing. But if you were stuck in the middle, what they called a sideline farmer, your deductions were capped at a measly $8,750. And guess where they put Mr. Craig? Yep, right in that very restrictive middle category. And here's the fundamental problem, the thing that lawyers had been pointing out for years. The law itself says you can get full deductions if your chief source of income is farming or a combination of farming and some other source. But that old Moldowan rule basically ignored the or part. It acted like, for the combination to count, farming still had to be the main event, which just collapsed the two options into one. And don't just take my word for it. In its final ruling on Craig's case, the Supreme Court itself said that the old Moldowan rule, quote, reads one of the exceptions out of the provision. Think about that. The highest court is saying its own previous ruling basically just ignored a part of the law that Parliament had written. But before the Supreme Court could fix its own mistake, something had to give. And the first cracks in this old law, the first signs of a rebellion, they started to show up in the lower courts. I mean, look at this. For almost 30 years, Moldowan was rock solid, untouchable. Then, in 2006, this other case comes along, Gunn versus Canada. And in that case, the Federal Court of Appeal actually criticized the logic of Moldowan and went in a different direction. It was the first real challenge, and it set the stage for a major conflict. So when John Craig's case finally went to trial, the lower courts actually sided with him. They chose to follow the newer thinking from that Gunn case instead of the old rigid rule from the Supreme Court. Now, that was a really bold move, and it created this totally unstable situation where different courts were saying different things. Only the Supreme Court could clean it up. And that's exactly what happened. The case landed smack in the lap of the Supreme Court of Canada, forcing a huge showdown. And now the court had to answer two really fundamental questions. Not just about tax, but about how our entire legal system is supposed to work. The first question was really about the chain of command. Do lower courts have to follow the decisions of higher courts, even if they have really good reasons to think that old decision is outdated or just plain wrong? And then came the second question, which was even more dramatic. Was the Supreme Court willing to do something it almost never does? Look in the mirror, admit it made a mistake decades ago, and formally overturn one of its own major, long-standing decisions. All right, so let's get to the climax of the story. The Supreme Court heard all the arguments, and it came back with a decision that was, well, a landmark.
Now, to really get how big a deal this is, we need a quick sidebar on a legal principle called stare decisis. It's Latin, it means to stand by things decided, and it's basically the bedrock of our whole system. It's the idea that the law should be stable and predictable. So overturning a precedent, that is not something courts do lightly.
And here is where the court's answer was so brilliant. First, they were firm. They said, yes, lower courts absolutely must follow precedent, period. That's how we maintain order and certainty in the law. But, and this is the huge part, the Supreme Court has the power to overrule itself if there are compelling reasons to do so. So why here? Why now? Well, the court laid it all out. They said, look, first, this Moldovan rule has been hammered by legal experts for over 30 years. Second, we now agree it was just the wrong interpretation of the law. Third, it just doesn't fit with how we look at tax law today. And then they made the ultimate call. In this specific case, getting the law right was more important than sticking with a predictable but wrong decision. So the old, rigid rule was officially thrown out. But what did they replace it with? This is the part that really matters for anybody with a serious side business today. Instead of those 3 rigid boxes, the court introduced a new, flexible test. Now, judges have to look at the whole picture to decide if your combination of work counts as your chief source of income. They'll look at the money you've invested, the income you get from each thing, and, this is a big one, the time you spend on each. They'll even look at your lifestyle and what you plan to do in the future. It's really just a more holistic, common-sense approach. And this is the bottom line, the crucial change. Under this new rule, your side business doesn't have to be the predominant source of your income. It just has to be a significant part of your life, a real, serious endeavor that you're committed to, right alongside your other work. So what did this mean for John Craig, the man who started this whole thing? Well, the court looked at his life, the huge amount of capital he invested, the fact that his mornings, evenings, and weekends were all about the horse business. They ruled that his horse racing operation was, quote, a major business preoccupation. The final verdict? The government's appeal was dismissed. Mr. Craig won. He could finally fully deduct his business losses. You know, this whole case leaves us with a fascinating puzzle that goes way beyond tax law. It really makes you think about what justice is. How should our legal system strike that balance between 2 really important things? The need for stable, predictable rules that we can all rely on versus the fundamental duty to just get the law right. The Craig case is this powerful reminder that sometimes, just sometimes, the pursuit of being correct has to win.